When people go into business together, nobody really likes talking about what happens if one of the partners dies. It's a bit like discussing where the office biscuits keep disappearing to. Everyone knows it's important, but somehow it never makes it onto the agenda. But in a general partnership, the death of a partner can have very real legal and practical consequences. And what happens next often depends heavily on one thing. Was there a partnership agreement in place? Now, before we dive in, if you haven't already watched our video on the key provisions every partnership agreement should include, it's worth checking that out afterwards, because this situation is exactly why those clauses matter so much. Death, retirement, disputes, profit shares, they all sound very theoretical until suddenly they're not. So let's start with scenario number 1, where there is a partnership agreement. If the partners were organised enough to actually sign an agreement before the crisis hit, then the process is usually much smoother. Most well-drafted partnership agreements will contain clauses dealing specifically with death, retirement, or incapacity. These clauses often say that the remaining partners can continue the business after the deceased partner passes away. That means the partnership itself doesn't necessarily come to an abrupt end. The surviving partners can usually keep trading, keep serving clients, and keep the lights on without descending into administrative chaos. The agreement will also usually explain what happens to the deceased partner's share. For example, it may say that the remaining partners can buy out the deceased partner's interest. Sometimes there's a valuation formula already agreed in advance. Sometimes there's insurance in place to fund the buyout. Practically speaking, the surviving partners would normally need to review the partnership agreement carefully, value the deceased partner's share, speak with the deceased partner's executors or personal representatives, update bank mandates and financial authorities. Where relevant, notify HMRC, regulators or suppliers, and importantly, make sure clients know the business is continuing, because nothing unsettles clients quite like hearing, "We're not entirely sure who owns the firm this week." Now, scenario number 2, where there is no partnership agreement. This is where things become significantly more awkward. Under the Partnership Act 1890 in England and Wales, unless there's an agreement saying otherwise, the death of a partner automatically dissolves the partnership. Immediately. Not eventually, not after a grace period, straight away, which means the partnership technically stops existing at the moment of death. And this catches people out all the time. You can have a perfectly successful business, trading for years, employing staff, serving loyal clients, but if there's no written agreement in place, one partner dying can legally pull the handbrake on the whole operation. At that point, the surviving partners can't simply carry on as though nothing happened. The partnership assets and liabilities need to be dealt with properly. Accounts need to be prepared, assets valued, debts settled, and the deceased partner's estate becomes entitled to their share of the partnership. In practice, the surviving partners often do continue the business in some form, but legally they may actually be starting a new partnership altogether, which can create complications with contracts, banking arrangements, tax registrations, leases, and client relationships. It's a bit like trying to continue a football match after someone's quietly removed the pitch. And emotionally, this all tends to happen at exactly the worst possible time, when everyone involved is already dealing with grief, stress, and the sudden realization that nobody knows the password for the bookkeeping software. So what's the key takeaway? A properly drafted partnership agreement is not just a legal formality, it's effectively a contingency plan for the business. It creates certainty, it reduces disputes, and it helps surviving partners and family members avoid turning an already difficult situation into an expensive legal headache. Because when someone dies, the last thing anybody wants is a frantic argument over who owns the photocopier and whether Dave's verbal understanding from 2009 was legally binding. So if you're in a general partnership and you don't yet have a written agreement in place, now is probably the time to fix that. And if you found this video helpful, make sure to like, subscribe, and check out our other video on the key partnership agreement provisions every business should have. Thanks for watching and see you next time.